All rise. The Court of Appeals Division 1 is now in session.
Morning. You may be seated. We're here today, the matter of State of Arizona versus Miles, real party and interest, Corey Wright. Our case number is SA150010. We'd ask you to identify yourself when you come to the podium, as well as your client. We have conferenced this matter already. We've considered the briefing. We hope we're familiar with the facts and arguments thus far, but we look forward to your arguments. With that, you may proceed.
Thank you. Good morning. I'm Lisa Marie Martin for the state of Arizona. And as a preliminary matter, there's 1 minute entry that was left off of our appendix, and I'm asking the court to take judicial notice of it. It is a minute entry dated 11/21/14, and what happened on that minute entry is that the Judge Miles denied the defendant's motion to suppress. And that's, I'll be explaining why I think that's relevant, but I'm sorry that minute entry got left off, and under Rule 201 of evidence, I would ask the court to take judicial notice. The question here is, did the respondent judge's ordering the state to reinstate a lapsed, expired plea agreement that had been turned down multiple times by the defendant violate the separation of powers? And the state says that it does. It's not a sanction under Rule 15.7. Just because Rule 15.7 says any appropriate sanction, it is not appropriate sanction or even a sanction under 15.7. It is an intrusion on the executive powers by the judiciary. And understandably, the respondent judge was, give me a case. Tell me why a rule that says I can do anything says that I can't do this. And what I could give him was cases showing when you can order a state to reinstate a plea agreement. And those are cases like Lafler versus Cooper or Fry versus Missouri or even Donald, where there's been a valid constitutional violation of effective assistance of counsel. And Donald also mentions some other instances. For instance, if a prosecutor refuses to offer a plea agreement because he has a personal animus towards a defense counsel, or if a plea is withdrawn for vindictive purposes. What we do have in Arizona, and this is even an unusual rule, is 15.8. And 15.8 actually says that if the state does not give material disclosure within 30 days before a plea offer expires, that the court then finds is material to the defendant's decision to reject the plea. And if the state then does not reinstate the plea offer, then the presumptive sanction is preclusion.
It's not really a separation of powers case, though, is it? Because you've just identified a number of situations where the court can order the reinstatement of a plea agreement. So there's no constitutional bright line. Isn't your argument more based on the facts of this case? Well,
what those cases say, Donald and the other cases, say that there is an intrusion and there is coercion. But in those cases, it's because you have a constitutional violation that makes that intrusion necessary or valid as a remedy.
It's all the more odd, though, isn't it, that ineffective assistance of defense counsel could warrant the court's intrusion into an executive function?
Well, it's odd, and the prosecution obviously doesn't like it, but the defendant has no way really to have an adequate remedy. If their counsel, for instance, didn't tell them about a plea offer or misadvise them about a plea offer, that may be the only remedy offered to reinstate, but they still have to show prejudice from it. The defendants still have to show that they would have accepted it and that the state wouldn't have withdrawn it in between for some other reason. Maybe the defendant committed another crime and that the court would have accepted it. So yes, I mean, technically those are violations of separation of power, but because of because of the considerations for the defendant, because there is a constitutional violation, those have been tolerated. Here, we don't have any constitutional violation. We don't even have any constitutional right to discovery before plea. I'm sorry.
What if we were to have a Brady violation? Would that justify a court ordering that a plea be reinstated?
If there were a Brady violation, Your Honor, I would say that would have to come under 15.8 because that would definitely be material. I mean, that would have to be material if it constituted a Brady violation. And I would note that Judge Miles here specifically declined to find a Brady violation. It was asked for as to one of the witnesses who was found to be no violation at all.
But if under 15.8, is that an available remedy for the trial court?
It's not. It's still even under 15.8. It's still not an available remedy to force the state to reinstate a plea agreement, and that's what the Arizona Supreme Court said when the Arizona Supreme Court looked at. Of course, I forget the name of the case, Longoria, Rivera-Longoria, the Arizona Supreme Court was considering, what is a deadline for purpose of a plea agreement. But the state had also said, we think this whole rule violates the separation of powers. We think this whole rule is unconstitutional. And the court said, no, it's not, for the very reason that it gives the state the choice of reinstating. It doesn't say you can't withdraw. It doesn't say you have to reinstate. But if you don't reinstate, your evidence is going to be precluded. So it doesn't force. And that's why our Arizona Supreme Court said that was not a violation of the separation of powers. And, I mean, it seems to me that this case comes under that, except here we have the reason that 15.8 wasn't asked for by the defense or dismissed by the judge was because it didn't apply in the sense that these two witnesses, the ones that he found were not seasonably disclosed, there was nothing material about them. Our trial counsel said, one of them inadvertently, I left off, he's on the third page of this short police report, and he's a minor witness, and he was basically trying to ameliorate any harm at the argument on the sanctions, saying, I don't even need to use him. And on the seventh witness, the federal probation officer, I generically listed all probation officers before, like I generically listed all officers in the police report, but I won't even need to use her unless the defendant denies that he committed a federal offense while he was on release. For this offense, he went and committed a federal offense, and he pled to that. And this person was was going to be his probation officer. And he said, I won't need to use her unless he testifies and denies he has that offense, or at sentencing to use it for aggravation. It couldn't be used as a historical prior because it had happened after the first one. But he was trying to ameliorate those things, and the court actually took that as making it worse, as saying, well, you're not even going to use these people, so precluding them isn't going to do anything to you, even though you're trying to help and you're trying to make this less burdensome. Precluding's not going to do anything, so I'm going to make you reinstate the plea agreement, reinstate the plea offer. And there's just no authority for that. I mean, if it wouldn't come under 15.8 because they are not material. They could not be material to the defendant's decision to plead. And the judge knew that. If you look at the argument on the motion to reconsider, I said, well, 15.8 wouldn't even allow you to do this. And he said, and I'm paraphrasing, I'm not going under 15.8. I'm going under 15.7, which basically says I can choose whatever I want. And the state feels that Longoria actually governs this case because if you look at 15.8, and the reason that Rule 15.8 is constitutional, because it doesn't force the state to reinstate a plea agreement, even when material discovery has been withheld or not disclosed, then how can it be an appropriate sanction under 15.7? How can 15.7 do an end run around 15.8 and the Arizona Constitution separation of powers when there's no reason, like a Sixth Amendment violation or vindictive prosecution or vindictive reasons for withdrawing a plea? It just simply violates the separation of powers. Unless you have any questions, that's really all the state has. Okay.
May it please the court, counsel. I'm Harla Davison, and I represent Real Party and Interest Corey Wright. First, thank you for your time. Your Honors, I do believe this is potentially a separation of powers issue. I haven't disputed that it is a separation of powers issue. The reason why I think it's a separation of powers issue is because this case is eerily similar to Donald. As this court is well aware, Donald was about the ineffective assistance of counsel and the court's remedial power to order the state to reinstate the plea offer.
Was there an assertion here that the defendant would have taken the plea offer if these two witnesses had been disclosed previously? Doesn't that make this different from Donald?
I can tell you that that's up for debate. The reason why that's up for debate, Your Honor, is because negotiations were ongoing all the way up until the time that
What
this
is it about
occurred.
these two witnesses that would have changed your client's mind about a decision to plead?
Well, first, I would say that Officer Bernal was one of the witnesses that we're discussing. Officer Bernal was at the scene. Officer Bernal, I never had an opportunity to interview, but Officer Bernal certainly could have provided more inflammatory or damaging or prejudicing type of information because he had direct contact with Mr. Wright at the scene.
But if she's precluded from testifying at trial, how does that change the analysis that your client was going through at the time of the plea? He wasn't aware of this witness. This witness isn't going to testify at trial. So what's the difference to him?
And, Your Honor, that wasn't the only witness. There was also the witness of the probation officer, Officer Madrid. That, if Officer Madrid would be allowed to testify, even in purposes of sentencing, it would be used to enhance or to increase punishment. So that in itself as well. Because
my question is if his decision on, with Donald, it's kind of a unique scenario because the defendant is saying, if I'd known this information, I absolutely would have taken a plea agreement. But here, we're suggesting that had I known that these people were not going to be allowed to testify, I mean, it presumably doesn't know about these two witnesses ahead of time, so they don't factor into his analysis. But these two witnesses are not going to be allowed to testify. So I'm having a hard time understanding why that would have changed his analysis of the plea offer.
And it may or it may not have changed his analysis of the plea offer, Your Honor. The reason why I think I would like to explain a little bit about how this case is so similar to Donald, and perhaps it addresses the issue a little bit better. It certainly isn't going to explain why his position would have changed on the plea, but it can explain why I believe that the remedy that the court chose was appropriate. In this case, there is still a constitutional violation. It is my position, and has always been my position, that the state has a duty to recognize the Constitution. It has a duty to exercise the Constitution, all of its parameters.
What's the constitutional violation?
Due process, Your Honor.
There's a rule violation.
There is a rule violation. That rule goes directly to discovery and disclosure, which then goes to notice.
Couldn't due process be satisfied if he has notice ahead of time, he gets a brief continuance? Would there still be a due process violation if he had a chance to consider it before trial?
I don't believe it would, because our rules allow for that.
What
But
if the
he-
rule were amended to allow a later disclosure? Would that be an unconstitutional rule?
May I get my water, please?
Sure.
Okay. There are those rules in place. I mean, you have 15.1, which sets out.
But they're
the-
not constitutionally required. Brady is a constitutional rule, but the timeframes under Rule 15 presumably could be adjusted if the Supreme Court chose to without offending the Constitution.
They could, but then there would have to be a decision made later on potentially that that rule is a constitutional rule, that it still falls within notice and due process. It's our position that due process is violated if appropriate notice isn't given. If somebody is noticed a witness while we're in trial, if there is a rule that is allowed, and there is, for a leave of court, to request of leave of court to then do further investigation for both parties, that is ample ability for the investigation, then that allows for appropriate due process. That is, the defense attorney in this case would be able to investigate that person, would be able to interview that person.
I think the rule really, according to its terms, is designed to promote the fair resolution of cases on their merits. But I'm not sure that there's anything about those rules that is necessary to establish the minimum required by due process. Do you have any authority to suggest that Rule 15 is constitutionally required at all?
I would just reflect back upon due process, Your Honor. A person is entitled to notice of, well, due process in the Sixth Amendment, I guess, also with effective assistance of counsel. An individual is entitled to notice. They're entitled to know who the witnesses will be testifying against him. They're entitled to confront and cross-examine those witnesses.
Let's say in this case, the same violation of Rule 15, and the court had simply ordered a continuance of 2 months to give you an opportunity to investigate, do whatever witnesses. Would there be some sort of constitutional violation with that type of order from the court? Would there be a due process concern?
I believe it would be a speedy trial rights violation, Your Honor. In this case, Mr. Wright's in custody. That would be a prolonged period of time for him to come to trial. It would give the state a benefit.
Assuming we're not butting up to a speedy trial deadline, is trying to just understand why Rule 15 somehow implicates due process.
The notions of fairness, I believe that's why. Again, getting to notice of the witnesses. Your Honor, we interview witnesses prior to trial. We do that generally well in advance of trial so that we can know if we need to have rebuttal witnesses, if we need to have experts. That's why the notice requirement, and I believe the notice requirement in the due process clause is implicated through the disclosure rules.
Even assuming that that's right, you got the remedy of having these witnesses completely precluded. Why doesn't that remedy cure any prejudice resulting from the violation?
Well, as Judge Miles pointed out, that remedy would have no sting. And why is a sting important in this case? Because Judge Miles also pointed out that to disclose 7 witnesses on the eve of trial, some of them were generically disclosed, meaning I may bring a witness to testify about restoration of rights, but not actually specifically notice the witness as required under Rule 15.1. But if the judge in this case says, well, there was no sting, it needs to have a sting, otherwise you are throwing a wrench in the defense's preparation for trial, and those were his words, and I completely agree with that.
What do you need to do to prepare for witnesses who won't testify?
That's a good point, Your Honor. I can tell you that in preparation for trial, and until the decision is made by a judge whether an individual would be precluded, your whole strategy changes. It potentially could change. I don't mean to say that it's going to happen every time, but potentially your whole strategy can change. And on the eve of trial, here, 7 days before trial, when I actually saw the witnesses, again, I was not ever officially noticed. I happened to be perusing ECR, a private practitioner's version of ISIS. I happened to be perusing it on another issue altogether and then saw it. So I never actually received notice of these witnesses ever. I saw it. When I saw it, it was on the eve of trial. And at that point, until we get a decision by the court as to preclusion, I have to rethink the entire process. That throws everything.
And so how much time was that then between when you had to rethink and when you would have had to go to trial?
Well, that until we got a decision by the court, we didn't even have a decision by the court until, I believe it was the 19th. We didn't even have a decision immediately. So I would say at least a week. By the time that I noticed it, I saw it.
But how did that affect your preparation? Did it keep you from doing something that you might otherwise have done with other witnesses that were in fact going to be called? Or?
Not necessarily in this case, but that's why I was talking about that it has a ripple effect on the rest of, I guess, my clients. It changes the way in which I can conduct my business with my clients. It slows down being able to do jail visits, having to go see Mr. Wright on the eve of trial, running out to talk to him about these changes. It changes everything. Just doing a jail visit, Your Honor, takes several hours to accomplish. That's a big chunk of your day when you could be preparing your cross-examination, for example, based upon an interview that you already had with the witness in this case.
If I could change gears just a little bit, I don't recall which case, discussing available sanctions. The court, I think it's in State versus Roque, suggested that one of the important factors to consider is how vital the witness is to the case. And here the court seems to have made a finding that these are not really vital witnesses, and that's why there's no sting in simply precluding them. But if the factor that the court is supposed to consider is how significant, how vital to the case, that it's a bigger deal if they're vital witnesses. But here, if they're not vital witnesses, why is any type of sanction necessary at all?
Okay. First, I don't concede that it wasn't a vital witness, either of the two witnesses.
Isn't that the premise underlying the court saying there would be no sting because the prosecutor said, well, I don't really need to call these witnesses anyway?
That's if the prosecutor decided not to call those witnesses. The prosecutor...
Didn't the trial court say that, though, in his order, didn't he reference the fact that the prosecutor had indicated that he didn't really need to call them, and so he didn't view simply precluding them as a sufficient sanction because it wasn't really enough to sting?
Right, and the state did indicate that it didn't need to call him. The state had never, at any time, did it state that it was absolutely not calling that witness. Otherwise, why would you notice a witness that you're not going to use, but unless you are trying to throw a wrench in the defense's case? So I don't concede again that this wasn't going to be a witness that wasn't going to be called. I would say that the state did make reference that it doesn't believe it would be necessary or is not sure it would call that individual. First, the state says, oh, it was inadvertent, I left that person off, which means I intended to notice that person as a witness, this person being Officer Bernal.
My reading of Roque, though, is that the assessment of whether to impose sanctions at least turns on how vital the witness. So are you disputing at this point that that these two witnesses that we're talking about were or were not vital? Are you saying they were vital?
I think they're potentially vital, and the reason why I say that is you're not talking about, one of them could be considered an ancillary kind of witness, and that would be Madrid. But again, Madrid's testimony would go directly to punishment, and according to the rules, even if it increases punishment, that individual needs to be seasonably noticed. But also, Bernal was actually at the scene. He was part of one of the arresting officers. So let's say that we're in the middle of trial. The state realizes, oh, I can't get into this evidence because I just got a ruling against me. Then I can just use Officer Bernal now. So Bernal is, in my opinion, a very viable and vital witness because it could cure some other defect in the state's case while we're in trial.
Isn't the sanction of precluding that testimony a viable sanction then? Doesn't that cure any problem that, for your client? They've precluded both of these witnesses.
Absolutely, but just as in this case, the state could go back and ask for a reconsideration of that motion, of that court's order, just as it did here.
But that hasn't happened. I mean, the witnesses are precluded, right? That's been settled.
Right, because he's pled guilty.
Well, okay, but had he been heading to trial,
Yes.
the witnesses would have been precluded.
The witnesses would have been precluded, but there is nothing to preclude the court from reconsidering that order.
Well, okay. Let me ask you this. It seems to me that the court's reasoning is a little bit upside down here, because what it's saying is that the sanction of preclusion, which cures any prejudice to the defendant, isn't all that serious here because these witnesses weren't all that important, and so we need a stronger sanction, which suggests that it's thinking that the strength of the sanction needs to be inversely proportional, not proportional to the severity of the violation. Shouldn't the severity of the sanction go up with the severity of the violation, not the other way around?
I think that's reasonable to believe. However, in this case, I think that the judge realized that what the state was doing was attempting to manipulate or change the defense's ability to prepare for trial. I think he saw that, and I think that's what he meant by throwing a wrench in the defense's preparation for trial. And he believed that the state should face a sanction, a punishment as a result of doing that. The judge could have taken more onerous measures. The judge could have dismissed the case outright. That would likely have been something too onerous for this type of violation.
Would have stung, and it wouldn't have implicated any separation of powers concerns.
Absolutely. But here, what the court did was put the parties back in their original position prior to the violation, and that's exactly what the Donald
But how
court
is it
did.
back in the original position? And I go back to Donald. Isn't there a requirement that a defendant who's making a Donald claim, isn't there a requirement that the defendant say, if I had known this information, I would have pled guilty?
For ineffective assistance of counsel.
Right.
Correct, but that's not what my argument is based upon. My argument is based upon another constitutional violation, not the sixth, but the fifth, under due process.
But either the only reason we've gone that route in Donald was it makes sense because there's no other remedy. The defendant is saying, if I'd had this information, my attorney never even told me about the plea agreement. There isn't really a very good remedy for that other than to reinstate the plea. But it seems like it's clear under Donald that in that circumstance you at least have to allege that I absolutely would have taken this plea agreement if it had been offered, but for my attorney's ineffectiveness, I would have accepted this plea. And that seems like a hard case for you to make for your client under these circumstances, that he absolutely would have accepted this plea, but for the state's failure to disclose two relatively insignificant witnesses who are now precluded from trial.
Right. But I think his showing of actually pleading guilty indicates that he would have taken that plea. Even after he gets the preclusion, he still takes the plea. My client was wanting to enter into the plea, and it's the position of my client that once he noticed that Bernal was going to be a witness, then he wanted to take the plea. Once Bernal is precluded, preclusion isn't necessarily permanent. As again, if something occurs in the middle of the trial and the state wants to readdress that original motion, it can do that. We've not had that ability to do that because he has pled guilty.
Well, it's highly speculative that the order would have been reversed at some point, and then you have a very strong position on appeal that if the witness is precluded and then allowed to re-enter during trial, that Rule 15.7 or 15.8 hadn't been served. But here, the court put your client in the position of having the plea or going to trial with a problem-free record. And so I don't even see how those sanctions work together. right? Because if he pleads, the preclusion's irrelevant. And if there's preclusion, then the plea seems unnecessary because he's in a position, the same position he would have been in had the rules been complied with.
I can agree to that analysis, Your Honor, but again, I cannot state that preclusion would be necessarily permanent. That's, and my basis for that is experience.
I don't think we have any further questions. Thank you both for your argument. We'll take this matter. I'm sorry, do you have a?
No, she can
Oh, sorry, if you'd like to make a summation or use the rest of your time.
talk about the state.
Oh, I
Yes.
apologize. Yeah.
Just forget about me.
Ms. Martin, my apologies.
Okay. First, I'd like to respond to the claim that the defendant heard about Officer Burnell and said, "Oh my God, I've got to take the plea back." I mean, that has never been, that claim has never been made before, and it's actually absolutely ridiculous. I mean, his name appeared once, as is in our record, his name appeared once in the police report. He had a minor role. He was inadvertently left off because our trial counsel actually read the police report and forgot to put his name down, but he was a minor witness. To think that the defendant would somehow say, "Oh my God, I'm going to go back and enter the plea that I twice decided I didn't want," because he kept on wanting less and less time, that the state said, "No, this is the least we're going to give you with all your priors and the fact that you ran out and committed a federal offense while you were on release for this." The other thing is that I wanted to get back, I never connected why I wanted you to take judicial notice of the motion to suppress order, is that on November 21st, a motion to suppress was denied. Now, the defendant had already filed their motion for sanctions on 2 days earlier, on November 19th, but the motion for sanctions didn't ask for any reinstatement of the plea. 1121, the motion to suppress is denied, and that's argued on December 9th. Now, suddenly in the argument,
It's denied on November 21st and argued on December 9th?
I'm sorry, the motion for sanctions is argued. I was going ahead of myself without explaining what I was saying. The motion to suppress was denied on November 21st. On December 9th, the motion for sanctions that had been filed on November 19th was argued. And for the first time, the defendant says, repeats, "Please preclude these witnesses," or dismiss the case. Or, since they gave us notice of these witnesses after our plea negotiations are over with, can you send us back into plea negotiations? Sounds like a 15.8 claim, but without any claim of materiality attached to it. And what the judge says is, can't send you back into negotiations, but what I can do is reinstate the plea. And then he says, "I'll take this under advisement." And so just that timing is a little bit suspicious. If these witnesses were actually vital and these witnesses were so important, why wasn't a claim made under 15.8? That would have been the appropriate claim to be made, not 15.7. And even under 15.7, I think it was Judge Swan, you said it was upside down. It's like the dog wagging the tail. You're supposed to look at the importance of the evidence, any prejudice. Even today, Mr. Wright's counsel could not tell us, other than, "Oh, it threw a monkey wrench into my whole practice," which is, somewhat incredible to believe, has not shown us how anything was changed for the two witnesses. As to 5 of them, there was no violation. It was these 2. One officer with a minuscule role, and this, she even admits that the other probation officer, minor, and our trial counsel tried to work that out, tried to say, "Look, I won't use them," and the judge precluded it. So it's like the dog wagging the tail to say that there was prejudice. There certainly wasn't any bad faith, and this certainly wasn't, even under 15.7, a remedy that fit the wrongdoing. The judge didn't even try to make any 15.7 findings. He just said 15.7 says I can do whatever I want. Then, in terms of Donald, when counsel says this is eerily similar to Donald, it is eerily dissimilar to Donald. It is not anything like Donald. Donald was an ineffective assistance of counsel claim, and if you look at 15.8 and the comments to 15.8, I know I keep going back to 15.8 because it's the only thing that's really linked to plea offers. If you look at 15.8, that was adopted by Arizona, and that's a fairly unusual rule. Also, to not only to have pleas be to be voluntary, but to have effective assistance, to have the attorneys have information that's material to be able to advise their clients. But they have to show that that information is material. And there really, it was no showing here that this information would have been material, or that these were vital witnesses, or that there's some remedy, a Donald-type remedy. The Donald remedy isn't unfettered and not connected to anything. There's not some general due process right to discovery. Yes, our Rule 15 does have a Brady-type section in it, and that reflects constitutional things, but there's not just a general due process right to have this this discovery. Okay, and then in terms of not putting the parties back in the original position, the parties are not put back in the original position. Witnesses had been interviewed. The state had successfully litigated a motion to suppress, and there is abuse and harm just to the system. Just like when the legislative...
They litigated the motion to suppress after the withdrawal of the plea agreement?
Yes. The plea agreement expired on October 29th, and the motion to suppress was litigated on November 21st. And the motion, or the hearing on the motion for sanctions was December 9th. And that's the first time that counsel for Mr. Wright said, can you send us back into plea negotiations now? I mean, it was kind of opportunistic. Suddenly, he wants this plea, and no wonder he's all over it. He wasn't all over it because of Officer Burnell. It was a very significant, very favorable plea compared to they were a day before trial. You know, the day that the judge made his ruling, Judge Miles, on December 12th, but actually electronically it was released on December 15th, and the parties were supposed to go to trial the very next day in front of Judge Ditzworth. So our trial counsel quickly did the motion for reconsideration. But in the judge's order, if you actually look at it, it says, oh, no, I'm also ordering them to reinstate the plea by 3:30 on December 15th. He not only told us that we had to reinstate the plea offer, but told us what time and what hour to reinstate it. So the state really believes that this is a violation of separation of powers, and just like it's a violation of separation of powers for the legislature or the executive to intrude on the judiciary. I'm sorry.
Would you agree at this point that preclusion was warranted?
Well, we didn't seek relief of that. Personally, I think that anything was harmless. I mean, I think that it was harmless, but we did not challenge the preclusion, and I'm told that these people are minor. We really don't need them, and
So you're not contending that preclusion was in any way an abuse of discretion?
I think that preclusion was actually too harsh in these circumstances, but having not appealed that, or having not brought that before the court, I feel like I can't really, but my personal opinion is that this violation was harmless. They were disclosed. She had notice of it, even if she didn't get a copy, which obviously she should have. The supplemental notice was filed 12 days before trial. The defense counsel saw it 7 days before trial. The judge found that it was disclosed within 7 days before trial, but that it wasn't seasonably disclosed, and said, you intended to disclose Officer Burnell. You said you did, and you said that was inadvertent, so that shows that you were going to do that. So that was not seasonably disclosed. And you knew the name of this probation officer. and you should have disclosed that. I would find, if I were a judge, which I'm not, I would find those violations harmless.
But there would be a basis, and under an abuse of discretion standard, that would presumably be within the trial court's discretion as an available remedy under 15.7.
Right, but that is an available remedy. And we have not challenged that. So we would ask that you do rescind the judge's order ordering the state to reoffer the plea agreement. It has now been entered but not accepted. Our trial prosecutor signed it under pursuant to court order, and it's in our appendix. I think it's Appendix 19, and crossed off the part saying, "I agree, this is a just resolution of the case." So we would ask that you stop that from being accepted by the court. Thank you.
Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course.